You're at trial, and now, in the middle of the trial, the judge is rendering decisions that go against you and your case. Can you do something about it? Can you get a do-over? Can you get a different judge to come in and take over and now hopefully get better results? Would you like to know the answer? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, it's really nasty outside today. It's cold, it's raining, there's massive wind, so I'm doing video today inside. So, the answer to the question that I raised in the title of this video is, no, you can't get a do-over in the middle of trial. When you go to trial, whether it's a medical malpractice case, an accident case, or a wrongful death case, especially in New York, now you're at trial. The judge who is overseeing and supervising your trial controls everything that goes on in the courtroom. And when I mean everything, I mean everything. The judge will be the one to discuss the law with the jury. The judge decides what evidence and testimony gets presented to the jury. The judge decides what photographs will be allowed to come in so that now witnesses can talk about it, so that now the jury can actually see that. The judge decides when to break for lunch. The judge decides when they're going to start back up again. The judge decides when they start in the morning and when they finish. And importantly, the judge makes rulings of law when another attorney objects to either certain questions or to certain evidence. And the judge has to make a snap decision about whether or not he believes the question should be answered, whether or not he believes that the evidence should come in, whether or not he believes that something should not come in. The judge controls all those aspects that go on in any individual trial. Now, you're worried because you believe that the judge is biased against you. Why? Because after a number of attempts to try and get certain evidence introduced, your attorney is getting very frustrated. Why? Because the opposite lawyer, the opposing lawyer, keeps objecting, and the judge keeps agreeing with the opposing adversary. So now you're getting in your mind that you are losing your case. Why? Because now the judge is frustrating your attorney and not permitting him to do those things that he wants to do. And you're thinking in your mind, there has to be a better way. Can we get a different judge? Can we get somebody else who really has a better understanding of the issues in this case, a better understanding of the law, to go ahead and now give you proper and correct decisions? The answer is, no, you can't. Ultimately, if your attorney feels that the judge is somehow biased and keeps making rulings against you and your case, the only real option that the attorney has, he's got basically two options. First option is to make sure that everything that goes on in the courtroom is on the record, which means that the court stenographer, the court reporter, who is now recording everything that goes on, is accurately recording everything that happens, and that there are no off-the-record conversations. And if there are private conversations between the judge and the attorneys, now at least your attorney will have an opportunity to tell the judge, or to ask the judge, I should say, to say, Judge, I'd like to put that conversation back on the record, so now I have a record of it. Why? Why would an attorney do that? So that now, if you lose your case, there is the potential and the possibility that you would be able to appeal anything that went on during the course of the case. You see, if something is not contained within the trial record and you lose the case, and now you want to appeal, and the only way you can possibly appeal is if the higher court, the appellate court, has something to look back on to see what actually happened during the course of trial. And the only way for them to do that is not, and they will not, rely on your memory, your attorney's memory, or the opposing attorney's memory, or the judge's memory. Instead, they rely on the actual trial transcript to see what actually occurred. And then the appellate court has to decide whether there were errors of law made with regard to certain rulings. And if there were, whether or not they believe that those errors made a difference in the outcome of your case. The second option that the attorney has, that your attorney has, if he feels that the judge is biased, is to ask for a mistrial, or to ask the judge to recuse himself while the dogs go off and bark their head off as I continue to shoot today's video. So what does recusal mean? Recusal means that now you believe that the judge is so biased that you are asking him to excuse himself from your case and get another judge to come in to take over and take his place. Will that likely happen? In my opinion, the answer is highly unlikely. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work here in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are still thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.